that is 35. Nothing changes. I will put contexture to that while referring to the Constitution of Kenya under Article 138 on the election of the President. Allow me, Honorable Senators, to refer to Article 138, 4A, which says, in a presidential election, a candidate shall be declared elected as a president if the candidate receives A, more than half of all the votes cast in the election, and at least 25% of the votes cast in each of more than half of the counties. Honorable Senators, we have 47 counties in Kenya. Half of that, my quick math tells me that is 24. Therefore, the express provision of this, of the Constitution, is that we cannot then say that if 38 counties voted, then they did not meet the threshold, because the law is clear that they have to be more than half of it. So what you're being told here is that we need to subtract the members who are not present and then lay the basis of having the two-thirds. Allow me to refer to the Constitution once again on the process of the removal of a governor. It's very clear. It is not something that has been created out of anything else, but it's in the Constitution. The framers of the Constitution were very specific under Article 33(1), and I will read Article 33(2). Sorry, this is the County Government Act, Section 33(2). It is specific that a motion under subsection 1 is supported by at least two-thirds of the members of the County Assembly. This, honorable members, is a specific motion. It is not a bill or any other motion that can be brought to the House. It is particular to the removal of a governor. We do submit, honorable senators, that even if the County Assembly Speaker sought to create his own rules on how to conduct this voting exercise, then the standing order number 1, which they have sought to rely, is very specific, and they have read selectively standing order number 1(1). What they didn't tell you is that standing order number 1(2) provides as follows. The decision made in paragraph 1 shall be based on the Constitution of Kenya, statutes of law, and the usage of forms, precedent, custom, procedures, traditions of the County Assembly of Nyamira, the County Assembly, and the Republic of Kenya within this jurisdiction. They have failed to refer you to any statute that provides for proxy. You have also been told that this is a norm at the County Assembly of Nyamira to use proxy voting. Then we pose this question, honorable senators. Should we then countenance an illegality on the face of it, which has these serious ramifications, including impeaching an elected governor on a basis that does not exist in law? Honorable senators, we urge you to consider our preliminary objection, and especially on this point on the threshold. If you are told that the issue of proxy have to be called as witnesses, that is fine. But then have we determined the first question on whether this motion met the threshold? The answer is a resounding no. We yield to that, honorable senators. Thank you.
Now, honorable senators, we have 6 minutes. Kindly shoot straight so that we can extract the most out of these 6 minutes. Senator for Nairobi City County.
Honorable Speaker, very interesting arguments have been made about membership, and I want to seek clarification from Council, especially Council for the Governor. On the question of membership, you have stated very well what Section 33(2) speaks about, that motion has to be supported by two-thirds of all the members of the Assembly. I want you to tie that to the provisions of Article 103(1)(a) on vacation of office. Upon the death of somebody, can that person be still referred to as a member of the Assembly for purposes of determination of membership? And therefore, Speaker, there is a very interesting point that was raised by Council for the Assembly. For instance, Speaker, if by catastrophe we have 35 members in the Assembly, 15 of them are in a bus, and the bus plunges into a river and they are no longer members of the assembly. If an issue of impeachment were to arise in determining 2/3 of those members of the assembly, is it the case for the governor that we will still use the number that was determined at the election in August of 2022? Thank you, Honorable Speaker.
Yes, Counsel for Governor.
Thank you, Mr. Speaker, sir, and thank you, Senator for Nairobi, for that question. My straight answer to that question is the impeachment process is governed by 3 pieces of legal provisions: Article 181, Section 33, and the standing orders. It does not anticipate a scenario whereby there will be a vacant that will have to last for so much, or rather for so long, such as to affect the business of the House. And let me just give this as an example. Assume that for a moment, half of the House is not present, either by tragedy or disaster. What happens to that House? Do we then reduce the threshold to the remaining 10 or 5? We cannot do that. So if there is a vacancy, it does not affect the threshold because the law has a mechanism of filling that vacancy. That would be my short answer to that issue. Thank you.
Senator Wambua.
Mr. Speaker, I have a similar question, but this time to the Counsel for the Assembly, Carter Keegan. Mr. Speaker, I want the lawyer to address me and address this House on the question of the membership of any assembly. At what point does that membership determine? Does it determine immediately after elections and after political parties have had an opportunity to discharge their obligation to nominate members? Or is it a moving target? Is it one number today, a different number tomorrow, a different number next week? At what point does this number determine? I thank you, Chair.
The Counsel for the County Assembly.
Thank you, Mr. Speaker, sir. It is the direct answer to the question from us is that it is a moving target. The reality of it is that at every given time, the representation has to continue. Various activities have to be done. There is need to approve budgets. There is need to determine issues. And therefore, the fact that there is a continuous need to attend to issues on behalf of the public makes it a moving target. And at every given time, the people who are available to transact the business on behalf of the people who elected them is the determining factor of the total bottom line number of people who are to vote. That's my answer to the question.
Senator Boni.
Mr. Speaker, I'm convinced by what the Counsel for the Governor Mutuma has said, that voting by proxy, you can't find it anywhere in the standing orders of the County Assembly or anywhere else. And yet, this is going to guide us to decide on your PO, Mr. Mutuma. Don't you think reading standing order in its entirety, we should give the County Assembly an opportunity to demonstrate to the House that the Speaker proceeded under standing order number 1 of the County Assembly, allowed by proxy, and maybe he did so because of some usage, some tradition that preceded that decision. Don't you think we should allow this to proceed so that we hear evidence to make a decision instead of just condemning them? No, you are wrong.
Counsel for Governor, you have a few seconds to respond.
Thank you, Senator Boni Halwale. An argument based on points of law or the interpretation of law cannot be a factual issue. It is based on legal arguments. They had that opportunity to submit, and that's why this Senate directed us to prepare written submissions and bring them before this House. That is why they've been given 20 minutes to demonstrate to you through legal arguments how the Speaker can rely on Standing Order number 1. There is no witness who is coming to testify on a question of law. It is purely an interpretation issue which does not require evidential interrogation. The purpose of going through a trial, honorable senators, is for you to look at the facts, to cross-examine the witnesses on their version of factual issues, and then render a decision of fact. Questions of law.
Counsel for Governor, time
Thank you.
up.
Thank you.
Now,
Thank you,
honorable
Mr.
senators, I will be giving my ruling at 2:30 on this particular matter. All right. Now, honorable senators, it is now 1:15 p.m., time to adjourn the Senate. The Senate, therefore, stands adjourned until later, today, Wednesday, 3rd of December, 2025, at 2:30 p.m. I'll take that again. Having dispensed with the pre-hearing meeting of senators, which was a closed-door session, it is now time to commence the proceedings of the proposed mover from office by impeachment of Honorable Amos Kimomi Nyaribo, the Governor of Nyamira County. By a letter dated Tuesday, 25th of November 2025, the Speaker of the County Assembly of Nyamira informed the Speaker of the Senate that at a sitting of the County Assembly of Nyamira, held on Tuesday, 25th November 2025, the County Assembly of Nyamira approved a motion for the removal from office by impeachment of Honorable Amos Nyaribo, Governor of Nyamira County. The Speaker of the County Assembly of Nyamira also forwarded the following documents to the Senate, being the record of proceedings of the County Assembly and the evidence adduced in support of the impeachment motion. 1. Copy of an approved notice of motion dated 11 November 2025, copy of an approved impeachment motion containing grounds and particulars with annexures thereto, copy of the public participation report, copy of invitation letter to Governor to appear before the County Assembly to respond to allegations dated 17th November 2025, copy of the County Assembly Hansard report dated 25th November 2025, copy of division of votes list, advocates for the County Assembly, and list of witnesses. Now, pursuant to Section 33(3)(b) of the County Governments Act and Standing Order 81 of the Senate Standing Orders, at the sitting of the Senate held on Thursday, 27th November 2025, the charges against the Governor of Nyamira County, as contained in the motion of impeachment by the County Assembly of Nyamira, were read to the assembled Senate. Now, honorable senators, as you are aware, the mandate of the Senate in relation to the proposed removal by impeachment of a county governor is provided for under Article 181 of the Constitution, as read together with Section 33 of the County Governments Act 2012 and Standing Order 80 of the Senate, Standing Orders. In particular, Article 181 of the Constitution provides as follows. A county governor may be removed from office or on any of the following grounds. 1, gross violation of the Constitution or any other law, where there are serious reasons for believing that the county governor has committed a crime under national or international law, abuse of office or gross misconduct, or physical or mental incapacity to perform the functions of the office of the county governor. Parliament shall enact legislation providing for the procedure of removal of county governor on any of the grounds mentioned in Clause 1. Section 33 of the County Governments Act 2012, Senate Standing Order 80, and the third schedule to the Senate Standing Orders provide for the procedure to be followed in the hearing and determination of the proposed removal from office by impeachment of a county governor. Specifically, Section 33(3) and Standing Order 81B of the Senate provide that the Senate may either by resolution appoint a special committee comprising 11 of its members to investigate the matter or investigate the matter in plenary. Now, honorable senators will recall that at a sitting in the Senate held on Thursday, 27 November 2025, the motion for the establishment of a special committee was withdrawn pursuant to Standing Order 70. This paved way for the default position, the hearing of the impeachment charges against the governor of Nyamira, to the mode of appearance before the Senate, whether in person by advocate or in person and by advocate. 3, the in person and by advocate. 3, the names and addresses of the persons to be called as witnesses, if any, and witnesses statements to be called as witnesses, if any, and witnesses statements containing a summary of the evidence to be presented by such witnesses before the Senate. The evidence to be presented by such witnesses before the Senate. And finally, any other evidence to be relied on. Now, pursuant to Rules 4B and other evidence to be relied on. Now, pursuant to Rules 4B and 7 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Senate Assembly, the Office of the Clerk of the Senate, received response reference number MNCA/Senate/1/2025 and dated 1st December 2025 to the invitation to appear issued to the County Assembly of Nyamira from Messrs. Mokua Ndubi and Company Advocates, who indicated that the County Assembly of Nyamira had appointed the firm to represent the County Assembly in the hearing, and that the County Assembly would equally appear in person and by advocates. The letter also indicated the list of counsel representing the County Assembly and the list of witnesses for the County Assembly. Pursuant to Rule 8 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Clerk of the Senate furnished each party with the documentation filed by the other party in accordance with Rule 6 and 7 of the Rules of Procedure. Now, honorable Senator, activity displayed through the digital clocks. In summary, the program states that today, Wednesday, 3rd of December 2025, the charges against the governor as submitted by the County Assembly shall be read out to the governor. The governor will be given an opportunity to take plea on each of those charges. The governor, this will be followed by
presented by the following council, led by myself, Elias Mutuma, accompanied by my learned friend, Zelma Bonuke, Ombui Ratemo, Branley Morethi. Those are advocates. Then we have Sylvian Joki, our legal assistant, and Michelle Makandi, our legal assistant. And then we also have Erastus Orina, who is the county attorney of Nyamira County, appearing in that capacity. Thank you, Mr. Speaker, sir.
Senator Fakitui, kindly take your seat. Now, honorable senators, ladies and gentlemen, on behalf of the Senate, I welcome the team for the County Assembly, the team for the governor, members of the public and the media to the Senate and to these proceedings. Finally, I now
actions to formally engage, endorse, and support unlawful, illegal, and unconstitutional bunge mashinani, directly undermine the legislative representation and oversight role of the County Assembly of Nyamira as established by the Constitution of Kenya 2010 and County Governments Act 2012, thereby constituting a gross violation of the rule of law and the principle of separation of powers. Allegation 2, gross violation of the Constitution of Kenya 2010 and the County Government Act 2012 and the Public Finance Management Act 2012 by assenting to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira. Whereas Article 175A of the Constitution of Kenya 2010 requires that the county government shall be based on the democratic principles and separation of powers exercised by its county assembly, whereas Article 224 of the Constitution of Kenya 2010 states that on the basis of the Division of Revenue Bill passed by Parliament under Article 218, each county government shall prepare and adopt its own annual budget and appropriation bill in the form and according to the procedure prescribed in an Act of Parliament, whereas Section 21, subsection 1 of the County Governments Act 2012 requires that the County Assembly shall exercise its legislative power through bills passed by the County Assembly and assented to by the Governor, whereas Section 130 of the Public Finance Management Act 2012 provides for the procedures of processing a county budget, including transmission from the county executive to the county assembly for consideration and approval. 1.
work is easy because I use ClickUp. Here's how AI makes complex work simple. With ClickUp Brain, I get AI updates on any project, so I don't have to dig through endless details. When I miss a meeting, Brain gives me a quick recap with all the key takeaways. Even long chat threads are condensed into bite-sized insights, so I